I was saying that I am very happy to be here, and I've written this paper in homage to Eugenio Buligin, that today I've come to know that he's called Yevgeny Viktorovich. I didn't know that. Well, no. Yes, the original. No, I'm very happy to know this. Well, no, I think that people who like me, that for many years have enjoyed his friendship and his generosity, owe to him a very special tribute. I think that legacies like that of Eugenio are quite exceptional in legal philosophy, and really deserve to be studied, developed, and criticized also. By the way, is what I am going to do here now. But in any way, through these critiques, I want to express all the affection, the admiration, and the gratitude I have for him. I will read, unfortunately, my paper, and I want to analyze some Buligin's ideas on the status of statements that identify legal duties and legal permissions. According to Buligin, a positivist theory of law cannot admit normative propositions that identify the content of legal norms. Those statements that apparently play this role, such as in Argentina, marriage between people of the same sex is allowed, have two possible interpretations. Either they express a proposition but they do not have normative content, or they have normative content but they do not express propositions. In the first case, the statement proposed as an example expresses an empirical proposition, such as in Argentina the Congress passed a bill which the executive signed into law, permitting marriage between people of the same sex. In the second case, the statement expresses a norm or a judgment of norm and adherence. That is, it is a statement that does not convey information, but rather practical attitude of the issuer. To be specific, the agent who pronounces it either authorizes marriage between two people of the same sex or manifests conformity with this fact. In somewhat different terms, Buligin asserts that the statements that express the content of a duty are ambiguous. They can be prescriptive, but can also be descriptive statements that inform of the existence of a norm. That being said, it should be clarified that Buligin distinguishes between four possible senses in which we can say that a norm exists. In three of these senses, existence is empirical, relative to a certain time and place, and can be described using true or false statements. On the contrary, according to the fourth sense, that the norm exists means that it is compulsory or binding. In this case, the existence is a normative property, but above all, and I want to stress this, it is at the same time an absolute property, not relative to a specific time and place. And the statement that expresses it are not descriptive but prescriptive. They are also norms. Well, as we know, in legal theory, is in general, the term validity and existence tend to be used interchangeable, and consequently, Buligin also distinguishes between a descriptive and a normative sense of the term validity. And in his opinion, a positivist theory is barred from using a normative concept, whether it be of existence or validity of legal norms. A theory of this time, a positivist theory, cannot maintain that the legal norm is valid in this sense, because in doing so, it would automatically be formulating prescriptions, or expressing moral acceptance. Therefore, in a legal statement like in Argentina, marriage between people of the same sex is allowed, is ambiguous. Either it expresses a norm or an internal statement that asserts the moral bindingness of a norm, or it expresses a proposition that asserts certain empirical facts, such as the fact that the norm is enforced or accepted, but there is no other option for bullying. In what follows, I will present some critical arguments regarding Bullying's thesis, and I will attempt to show that there is another option. If my reasoning is correct, it can be claimed that Bullying's thesis is not coherent with the positivist and normativist theory that he assumes with regard to law in general. Furthermore, as opposed to what Bullying appears to presume, normativist positivism uses a concept of existence or validity that doesn't correspond to any of the senses that he has highlighted. Accordingly, I will attempt to maintain that for this kind of positivism, firstly, the existence or validity of a norm is not an empirical property, although it is a property relative to a specific time and place. At the same time, even though it is not an absolute property, it is a normative property. Secondly, in this perspective, it is perfectly possible to formulate true or false propositions about legal, valid, or existing norms. These are not empirical propositions, but they cannot be equated with propositions regarding absolute properties or entities. In this context, I'm taking as a starting point one fact that I will not discuss here, and it is that within a positivist conception of law, Bullying defends a normativist position. This position maintains that law is a set of norms, and more precisely, it proposes a complex thesis that challenges two types of reductionism. On the one hand, this position rejects that legal norms are empirical entities. On the other, it rejects that legal norms exist in the same sense in which it is usually admitted that moral norms exist or are valid, in an absolute sense, independent from any behavior, belief, or human attitude. In other words, this kind of positivism, unlike exceptical realism, maintains that legal norms exist and they are effectively norms, that is, abstract entities, meaningful deontic contents, not reducible to empirical facts. Thus, unlike natural law theories, it maintains that these abstract deontic entities become existent or valid only by virtue of certain behaviors, beliefs, and or human attitudes. Normativist positivist conceives of legal norms as entities whose existence form part of social reality. In other words, it assumes a kind of constructivist conception of legal norms. In my understanding, this conception is an especially good fit for Bullying's theory of law. Even though it is not a topic that he explicitly discusses, there are several elements in Bullying's approach that make it coherent with the constructivist approach. Just to mention one, when Bullying talks about Eberhard's proposal, he explicitly accepts that foundation of any concrete legal system can be found in the acceptance of a conceptual rule which is constitutive in nature. In accordance with this conception, a legal norm exists or is valid only if the circumstances established in an accepted constitutive rule or pattern are verified within a certain time and place. For this reason, each time that these circumstances occur, we are justified, epistemically justified, in affirming that a legal norm exists, or, which is the same in this context, that certain content is legally valid. As we can see, this is a relativist conception of the existence or validity of legal norms. And as I have just said, in my opinion, there is no difficulty in attributing this position to Eugenio Buligin. Thus, for normativist positivism, there are two types of facts that we should not confuse. On the one hand, the fact of accepting the foundational constitutive framework and the verification of conditions set out by it as norm generators. On the other hand, the existence of a constitutive rule pattern and that of a specific legal norms which can be identified using this constitutive pattern. As we have seen, these legal norms do not exist, and we could never identify them unless certain agents adopt the internal point of view and accept the specific constitutive framework. Especially, we can say that the facts that a constitutive rule is accepted and its condition of application obtained explain from an external point of view the fact that from an internal point of view certain data are taken to be validity criteria or certain deontic logic norms or contents are considered valid legal norms. In this way, statements like in Argentina a norm is legally valid only if it is passed by a body representing citizens, or in Argentina, a legal norm exists that allows marriage between two people of the same sex, even though they assume that certain empirical facts are verified, they are not synonymous with nor equivalent to empirical statements about facts. But as we have seen, Buligin refuses this interpretation. He denies that we can know and make true or false propositions about the legal validity of the legal existence of normative contents without reducing them to empirical events or without turning ourselves into believers in their absolute validity. What I will do is to take into account some reasons adduced by Buligin in favor of his position. Well, I'll try to resume. And one consideration by virtue of which Buligin denies the possibility of referring to duties that are not reducible to empirical facts can be summarized in the following way. A legal statement that purports to inform about the content of a duty would constitute an inadmissible hybrid. In effect, upon reflecting on the status of the internal statements of Hart's theory, statement produced for those who adopt the internal point of view, Buligin maintains that they are disguised way of formulating rules or aspiration based on rules. Understood in this way, these statements seem to be descriptive and normative at the same time. Nonetheless, unfortunately, Buligin does not offer any argument in support of this opinion, according to which when an internal statement is uttered on the legal validity or existence of the deontic content, we would be carrying out a sui generis type of act with a simultaneous two-way direction of it. He only reaffirms that this is what we would be doing. We would be uttering either a true or false statement, that is a proposition, but we would also be placing ourselves in the internal point of view and expressing moral acceptance about it at the same time. If this were the case, Buligin would be right, and we would have to admit that the internal statements or normative propositions understood in this way are semantic entities with a double direction of fit, but as Buligin maintains, that they are not authentic propositions, but rather disguised prescriptions. However, I understand that this is not necessarily the case, and that Bulligin's predicted result is produced only if a restricted and inappropriate idea is adopted regarding the notion of acceptance, internal point of view, and internal statements. In Bulligin's perspective, the problematic nature of legal statements that identify norms stems from the fact that they presupposes the adoption of the internal point of view, which he assumes is a moral commitment, the belief in the validity of the norms in the absolute sense. However, I think that we can ask if this truly what those who pronounce or affirm a normative statement are committing themselves to. I would say that the answer is no. We know that the notion of acceptance and the internal point of view can be understood in different ways. There is a way that I think that it is that provokes Bulligin refusal, in which those who seek to identify normative contents belonging to a system not merely act with an epistemic interest, but also admit to being subject to the practical consequences that follow from this normative system. In this case, there are two possibilities. It is certainly possible to accept the basic framework because it is considered to be objectively correct, independent from any belief or human attitude that is valid in an absolute sense. But this is a strong attitude, one of an individual who is a true believer in the law, that is not at all necessary or usual. In general, the framework of a legal system is accepted for a great variety of reasons. For instance, to be able to invoke the rights that the system confers so as not to lose a source of economic gain, not to be punished, etc. Or even for no reason at all, because it's routine. In this second hypothesis, the assumption of the internal point of view means not only accepting that certain legal norm exists, it also means seeing ourselves as agents susceptible to being reached by the set norms, that is, included in the personal sphere of application of this norm. It is true that in a formal sense of morality, in which morality is understood as any set of principles accepted as the ultimate basis for justification of our decision and actions, it could be said that this position assumes a moral commitment. However, it should be emphasized that according to this interpretation, morality is completely devoid of content, and that in this sense, any action has a moral justification as far as it is based on certain norms that are accepted as ultimate principles of justification. In any case, what is interesting to notice is that in this type of hypothesis, the acceptance of a constitutive framework neither presupposes nor implies a belief in the substantial merits of its universal or absolute validity. In short, it is true that, as Bulligin points out, the identification of the content of the law is made through internal statements. In accordance with our example, for instance, for a certain act like that of marriage to be permitted, certain actions have to take place. The writing, signing, and publication of a document that authorize it. These acts could be identified from an external point of view without accepting the constitutive framework. Nevertheless, it is not possible to claim that they are the foundation or the reason that justifies or directly constitute a permission to marry without at the same time accepting and using the constitutive framework that establishes in that way. That certain circumstances or behaviors established by an accepted pattern have the property of being a foundation, criterion, or reason for affirming that specific permissions or duties exist or have legal validity is not a natural or empirical property of these circumstances or behaviors. It is a property that they have in virtue of being established by the content of the constitutive pattern that we accept and use. In other words, we can only see them as circumstances or acts creating a legal norm once we have adopted the internal point of view and accepted said pattern. However, it's completely contingent fact that this acceptance is based on a moral principle, except in a merely formal or void sense in which a moral principle is any principle accepted as a final one. Of course, it should not be ignored that the expression acceptance and or adoption of the internal point of view in legal theory are also used as synonymous of substantial moral approval or belief in validity in an absolute sense. In fact, this is the sense in which Bullying is using them. Nevertheless, if what has been said in this section is correct, the claim that normative contents have the not natural, not empirical property of being legal norms, it is not necessary to assume or find ourselves in this position. As a final consideration, it can be conjectured that one of the main reasons for which Bullying rejects the possibility of proposition with normative contents is that they imply the collapse of the fact-value dichotomy and the admission that, of the existence of normative events. Bullying says so explicitly, and I quote, "It cannot be maintained that internal statements are prescriptive or normative and at the same time true or false unless one is willing to accept the existence of certain peculiar facts which make them true, namely moral normative facts." All normative facts for Bullying are moral facts. That's the point, I think. It is clear that Bullying rejects this kind of facts and does not believe that a positivist conception can offer a good explanation of them. Furthermore, in his opinion, Herbert Hart also rejects them. However, in spite of what Bullying thinks, it is appropriate that a theory like Hart's can be appealed to in order to explain these facts. In this author's conception, Hart's conception, to say that a norm is legally valid, in fact, implies affirming from an internal point of view a normative fact. The fact that something is forbidden, permitted, or obligatory from a legal point of view. Denying this time of facts would constitute a flagrant contradiction within a theory which actually defines itself as normativist, because it accepts that normative entities, prohibition, permissions, duties, which are different from and not reducible to empirical entities, can exist and be legally valid, even when they are not valid or binding from an absolute moral point of view. In accordance with that I have argued here, legal positivism is perfectly suited to explain what the existence of these normative facts consists of. In other words, a positivist theory is perfectly suitable for admitting internal legal claims that identify legal duties, prohibition, or permissions and whose truth or falsehood is determined by a specific type of normative facts, that is, the existence of a legal norm. I think at this point that it's appropriate to ask how it is possible that a theory like Bouligin's theory, which admits the law, that law is made up of abstract entities, rejects at the same time that these entities can be known, and this knowledge is expressed in propositions that are not reducible to empirical propositions. In my opinion, the answer to this question ought to be found not only in the fact that Bouligin assumes a restrictive moral conception of what it means to adopt an internal point of view and affirm validity in a normative sense. In the first place, Bouligin's theory continues to be victim, in my view, of the apparent dichotomy according to which only two kinds of entities can exist. There are empirical entities whose existence is relative to a certain time and place, the three descriptive senses of existence proposed by Bouligin, or there are abstract entities whose existence is absolute, independent from any time and place, the fourth normative sense of existence proposed by Bouligin. In other words, even if Bouligin apparently distinguishes between four senses of existence of norms, in reality what he is doing is distinguishing between four concepts or ways of understanding norms that, if they exist, they do so only in one of these two senses mentioned above, which he considers exclusive and exhaustive. Nevertheless, as we have seen, as long as it is possible to offer a good theory to account for the way in which some abstract entities can exist without being independent from empirical entities, it is possible to claim that, just as Bouligin understands it, the contrast between abstract entities, absolute, and empirical, relative entities represent a false dichotomy. In the second place, Bouligin curiously seems to have overlooked the fact that defines a legal theory as normativist. A legal theory is normativist, not reductionist, only if it allows distinguishing between, on the one hand, the existence of empirical facts that give rise to legal norms, and on the other hand, the existence or validity of legal norms. By identifying the content of a specific constitutive rule, we identify that which constitutes a relevant criterion, reason, or property in order to justify from an epistemic point of view that a content is legally valid. In other words, the acceptance of a specific constitutive pattern and the verification of the conditions provided by it explain, as I have said, from an external point of view, why something is, from an internal point of view, a relevant consideration to justify the normative proposition we formulate. For this reason, the debate about which facts or considerations are relevant for affirming the existence of a legal norm necessarily is an internal debate about the content of an accepted foundational rule. In short, and I finish with this, for normativist positivism, law is a set of norms. For these reasons, the propositions that identify norms are the only ones apt to express the knowledge of law. If the constructivist conception that has been summarily sketched out here is appropriate for explaining the sense in which legal norms exist or are valid, this implies that one more sense should be added to the four indicated by Bouligin, According to this last meaning, legal statements that assert the legal existence or validity of a norm do not express an empirical fact, but they neither can they be assimilated with the statements about existence of an absolute moral in an absolute moral sense. Legal existence or validity is a non-natural property that a certain semantic content has if and only if the circumstances laid out by an accepted constituted pattern occur. The acceptance of this pattern does not explain why semantic contents are normative. It explains why semantic contents, whether it is normative or not, has legal validity. That is why it becomes part of a legal system and valid from a legal point of view. That's it. Thank you.